May I please, Lordship? I beg to mention item number 4, Lordship. This matter will argue by D.K. Bhattacharya, Lordship, and he has some personal difficulties, Lordship. So let the matter be come up after 2 weeks, Lordship.
As paid for by the appellant's counsel, this matter stands adjourned for the day. Yes.
May I please, your Lordship? Lordship, I am seeking an adjournment in item number 8, your Lordship.
Item number 8.
Lordship. And 7 and 8 are analogous, your Lordship. 7. Yeah.
Objection is not filed, my lord. Objection.
Lordship, 8 I have filed, but 7, I have got the records of the objection. She didn't receive the copy and it's not on record. Some miscommunications there. Lordship, I'll instruct my clerk, your Lordship, to find the same.
You are seeking adjournment in 8.
Lordship.
And
8.
no objection has been filed in 7 according to her.
Lordship, copy has not been served on her and it's not on record also.
So you write like this. Your name, please?
S.A. Hussain, your Lordship.
Mr. S.A. Hussain, learned counsel, appearing for the applicant in this case, 6 adjournment on the ground that his senior is unavailable.
Yes.
Full stop. Miss B.D. Sharma, learned legal aid counsel, appearing for the applicant in item 7, if the case number submit that no copy of the objection filed by the state has been served upon her. Full stop. Since item 7 and 8 are interconnected, are tagged together, these matters cannot be taken up unless affidavits have been exchanged, unless copies of the affidavits have been exchanged between both the parties. In view of the above, and on the request of learned counsel for the parties, these matters are directed to be listed again after 2 weeks. In the meantime, the learned APP to furnish copy of the objection filed on behalf of the state to Ms. B.D. Sharma, learned legal aid counsel.
A date may be fixed, my lord.
After 2 weeks.
Much obliged.
Yes.
Item 1.
It's a jail appealer.
None appears for the appellant. This is Chan, learned APP Assam is present on behalf of the state. Since this is the appeal, this is a jail appeal, hence registered to engage an amicus curiae to represent the appellant and list the matter thereafter by reflecting the name of the amicus curiae in the cause.
Item 2.
Item 2 has been.
Present application's conviction for children to life law.
4 has been examined. Yes, what is that?
Life law, 302/34. Sentences imprisoned for life. But with the application after received the
This appeal is presented against the judgment dated 11/8/2022, passed by the learned session judge, Jorhat, in connection with sessions case number 172 bracket J-J bracket public 2018, convicting the appellant under section 302 of the IPC and sentencing him to
life.
rigorous imprisonment for life, and also to pay a fine of
1,000.
rupees 1,000
In default, SI for 1 month.
in default, SI for 1
1
month.
month.
Full stop. We have heard Mr. D. Talukdar, learned counsel for the appellant. Stop. Also heard Ms. S. Jahan, learned APP Assam representing for the state. Admit the appeal, issue notice, and a call for the LCA. Stop. Issue notice, return to 6 weeks. Since Ms. Jahan has accepted notice for the state, no formal notice is required to be sent. Only one respondent.
Only one.
Yeah, actually, younger brother of the informant died. So it's a
Nowadays it's not
302.
required.
Yeah.
No formal notice is required to be sent. Please list the matter after receipt to website.
I is there.
So also for the applicants, so and so for the state to submit that 2 weeks time be granted for filing objection, prayer allowed. Let this matter be listed again after the objection is brought on record.
Must.
Objection on behalf of the state is brought on record.
For orders, item 3. Objection দিছে? নকৰা? না, second of all,
Please, your lordship. Lordship, kindly, this matter may take at too long, if possible, lordship.
That is not possible. Today at 2 is difficult.
Lordship, in
Next
past,
week, the bench is changing. You take adjournment then.
lordship.
Yeah. What is this, why this article has been listed today?
Lordship, for suspension of sentence and consideration of bail, lordship, and they have already filed objection, lordship.
Heard Mr.
I.U. Chaudhary, lordship.
Ayush Chaudhary, learned counsel appearing for the applicant. Ms. B. Guya, learned FPP Assam State, of the state, and submit that objection has already been filed on behalf of the state. Stop. However, the applicant's counsel seeks posting of this matter again in the next.
Next week, lordship, and it- date may be fixed,
In
lordship.
view of the above, let this matter be listed again on 25th of
Lordship, highly honored.
November. In view of the above and as requested by the applicants, let this matter be fixed again on 25th of November. Fixed now, listed again.
Lordship, I'm sorry, on the last occasion made a wrong submission. The copy was not served on me properly. Actually, I was carrying a wrong file. I was under the impression that Lordship, there's a mistake on my part. I seek apology, Your Lordship.
This is a for IA for consideration of bail and suspension of sentence. The petitioner has been convicted for life. Now there is six accused charge. Out of 6, madam, 5
Please speak near the microphone. You are not audible. How many applicants?
one madam. One has been convicted, 5 have been acquitted. There is 6 were charged. The prosecution case is that
Convicted under 302.
302.
Yes.
The prosecution case is that, my lord, the accused persons were trying to hang the dead body of the deceased on a bamboo rope behind the house of the PW2. PW2 saw that incident and it was, the complaint was filed. And the time of incident is 2 AM at night, and it was raining, it is admitted, and it was dark night. On the basis of a lamp, he identified the petitioner appellant. The others have been acquitted. Your lordship, kindly see the judgment. Why the others memo copy.
Which page is the impugned judgment?
Impugned judgment, it starts from 15.
No, relevant part, please.
Relevant part, my lord, your lordship, kindly page 51. Para 71, your lordship, kindly see. Para 71.
Yes.
It is thus found that except the presence of Fulchand, that is petitioner, it would be difficult to place reliance on the prosecution evidence regarding the presence of other accused. I don't propose to theorize that Fulchand was alone.
You are reading from para?
Para 71.
Yes.
It is thus found that except the presence of Fulchand, it would be difficult to place the reliance on the prosecution evidence regarding the presence of other accused. I do not propose to theorize that Fulchand was alone at the residence of PW2. Rather, what it is revealed that evidence of the presence of other accused accomplices are found to be doubtful because of varying evidence on their names. A reasonable doubt therefore hovers on their presence, and they are found to be entitled to benefit of such doubt. Then you,
What is the evidence against PW2?
PW,
Against your
my
client?
name, he has stated she has stated my name.
Where is it? Let us see.
It is a PW2 one.
PW2 page 21.
Para 11.
para 11.
Yes, please read it.
PW2 Musammad Alisa Khatun is the mother of the deceased Saddam Hussein. She deposed that her son Saddam had gone to Jania Bazar with accused Taramia and Mainuddin to watch CD, but did not return till late night. She deposed that at night at about 2 a.m., she heard movement of people on the backyard of her house, and then she came out of her house with a lamp in her hand. She witnessed the accused person wrapping a rope on the bamboo bar on the backyard of her house, used for drying clothes, while the dead body of Saddam was lying on the ground near the accused persons. She deposed that she saw accused Taramia, Fulsan, Miachan, Fazal, Jahangir, and Jalil. Accused Taramia showed her and also accused ran away. She deposed that in the meantime, PW1 Firdaus Ali also rushed to the place of occurrence, and they found that the Saddam has already died. She deposed further that she saw 2 sharp cutting injuries on the backside of the head of the deceased Saddam, and there were other injuries also on his body. In cross-minor. In her cross-examination, PW deposed that the distance between her house and the house of Firdaus is about 4 to 5 km at the time of occurrence. Wife and children of Firdaus were available in his house. She admitted that Abul Haq is her neighbor. She deposed that the bamboo bar used for drying clothes is at distance of about 4 to 5 km from her house. She also admitted that at the time of occurrence, there was flood around her house. She admitted that though the night was dark, but people could be recognized with the help of the light of a lamp, and she had a big lamp in her hand. Apart from this, PW2 was confronted with the previous statement made under section 61 CRPC, and it was suggested to her that she has made improvements in her evidence. PW2 though denied those suggestions.
What other evidence is there?
My lord, her husband, my lord, PW husband also deposed. He came later on. Only she, my lord, came to the place of incident first. She shot.
Please pull the microphone, please.
To all of
What
it.
is the problem with the sound here?
The PW, her husband also deposed, and she came to the place of occurrence later on. Later on, he also said that yes, the persons fled away. All the accused persons. Now,
Who is that PW?
PW4. That is page 24, paragraph 15. PW4, father of the deceased.
Where is the postmortem report? How many injuries?
Evidence of PW9 at page 28.
Age?
28, my lord.
Page 20. Well, the Lordships kindly see paragraph 18, page 62. What is the findings?
It was a sound lower than will rise. I can't hear the matter like this. क्यों बारे बारे तो कमी को ऐसे? Can you please pull the microphone a little closer to your?
Itu nahe itu.
Yes, let us see whether it works.
Honest manner.
The Lordships kindly see page 62, paragraph.
Honest man. No, only nine. This is working. Yeah, he's a company. This one is working.
Just a minute, just a minute. Will you stop the streaming, please?
It will come to this.
To paragraph 89. Why? Yes, why? Of PW2. My lord, what is they? Because of varying evidence, not only the role played by the other accused are found to be hazy, but their precise presence at the residence of PW2 has also been found to be incoherent. The evidence, though undoubtedly establishes that accused Fulson committed the murder of Saddam with the aid of some persons. The question now is whether accused person can be convicted for murder for simplicity. It is stated that with the aid of some other persons, not the charged. So we can presume that the charged person, the accused, they were not participant in the commission of the offense. Some other persons were present as per these findings. If it is so, my lord, the Supreme Court says, for that purpose, you have to show, you have to prove that other person, with the aid of other persons, this person has committed the offense. It is the definition. Supreme Court has clearly stated.
You move that side, yes. That's all enough. You can come this side. Yes, Miss, we are.
Lordship. The ingredients against the accused person, my lord, accused appellant, is your lordship PW3 saw the accused person behind the dead body, my
Along
lord.
with the 5 others.
Lordship,
Along with 5 others.
lordship, and your lordship, PW3 says, prior to that, the accused person, my lord, gave warning to the deceased, my lord. Gave warning to the deceased. If he goes through that path, will lordship serious consequences, my lord. And PW4 and 6 saw the accused person running away from the place of occurrence. And your lordship, I have understood your lordship contention. Other persons acquitted and he was convicted. In that regard, I want to place one citation, my lord.
On the same evidence.
Yes, 2011 5 SCC 423.
On
Shaji.
same evidence, the court has convicted 1, whereas acquitted 5.
Yes.
That itself is a ground to examine the matter.
But your lordship, his specific allegation against him that he gave warning beforehand, there's threatening on the part of the accused person prior to the date of incident. And your lordship, this person was saw running away. He was found behind the dead body, which was seen by the mother of the accused, mother of the victim, your lordship. And your lordship, other persons acquitted, this person convicted on that ground, Honorable Supreme Court, on earlier occasion in 2011 5 SCC 423. Lordship, there's a judgment, my lord. Paragraph, my lord. Paragraph 9 to 12 and 16. May I read your lordship?
Yes.
Insofar as the second submission of the learned counsel for the appellants is concerned, it is true that out of the 6 named persons, 2 were acquitted by the trial court and only 4 were convicted under 302 read with 149 IPC. On the other hand, Mr. TSR Venkata Ramanna, learned counsel appearing for a respondent state by drawing our attention to the judgment of the Constitution bench in Mohan Singh versus State of Punjab, submitted that even after acquittal of the 2 accused in order to bring home the charge under section 149 IPC, it is not necessary that 5 or more persons must necessarily be brought before the court and convicted. The following principles laid down by the Constitution bench in Mohan Singh case are relevant for our consideration. The true legal position in regard to the essential ingredients of an offense specified under section 149 are not in doubt. Section 149 prescribes for vicarious or constructive criminal liability for all members of an unlawful assembly. When offense is committed by any member of such an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object. It would thus be noticed that one of the essential ingredients of section 149 is that the offense must have been committed by any member of an unlawful assembly, and section 141 makes it clear that it is only where 5 or more persons constituted an assembly that an unlawful assembly is born, provided, of course, the other requirements of the said section as to be common object of the persons composing the assembly are satisfied. In other words, it is an essential condition of an unlawful assembly that its members must be 5 or more. The argument, therefore, is that as soon as the two Pyara Singhs were acquitted, the members of the assembly was reduced from 5 to 3, and that made section 141 inapplicable, which inevitably leads to the result that the section 149 cannot be invoked against the appellant. In our opinion, on the facts of this case, this argument has to be upheld. We have already observed that the point raised by the appellant has to be dealt with on the assumption that only 5 persons were named in the charge as persons composing the unlawful assembly, and evidence laid in the course of the trial is confined only to the said 5 persons. If that be so, as soon as 2 of the 5 named persons are acquitted, the assembly must be deemed to have been composed of only 3 persons, and it clearly cannot be regarded as an unlawful assembly. In dealing with the question as to the applicability of section 149, in such cases, it is necessary to bear in mind the several categories of cases which come before the criminal courts for their decision. If 5 or more persons are named in the charge as composing an unlawful assembly, and evidence adduced by the prosecution proves that charge against all of them, that is a very clear case where section 149 can be invoked. It is, however, not necessary that 5 or more persons must be convicted before a charge under section 149 can be successfully brought home to any member of the unlawful assembly. It may be that less than 5 persons may be charged and convicted under 302-149 if the charge is that the persons before the court, along with others named, constituted an unlawful assembly. The other persons so named may not be available for trial along with their companies for a reason. For instance, that they have absconded. In such a case, the fact that less than 5 persons are before the court does not make section 149 inapplicable, for the simple reason that both the charge and the evidence seek to prove that the persons before the court and others number more than 5 is all, and as such they together constitute an unlawful assembly. Therefore, in order to bring home a charge under section 149, it is not necessary that 5 or more persons must necessarily be brought before the court and convicted. In view of the decision of Constitution bench of Mohan Singh case, in the case on hand, even after acquittal of 2 accused from all the charges leveled against them, if there is any material that they are members of an unlawful assembly, the conviction under 302 can be based on the aid of section 149.
That has got nothing to do with this.
Lordship.
This case. Or
May I read para 16
You
also?
read,
my lord?
but first, please understand what.
My
you
lord.
read.
My lord.
What you have said just now.
My lord.
Nothing to do with this case.
Lordship, in this case, yes.
Actually, you finish.
No, I will not. I will not. Lordship.
We are saying that the entire case is based on testimony of PWs 2 and 4.
2, 4, and 6, my lord.
All right, 2,
Yes.
4, and 6. These witnesses have named the applicant and 5 other persons. No specific role has been ascribed to any of the accused persons. What the witnesses said that they saw these 6 persons in the backyard of their house who were trying to do something with the dead body, which is lying in the ground. That's the evidence.
And there is no explanation from the.
All right. So 6 persons were there. They found that these persons were carrying the dead body, trying to hang it or whatever,
In this manner.
and when they came out, they ran away. Correct? This is the sum total of evidence, right? Why single out one person as the convict and
Lordship,
not others? That's
yes,
the
my
question
lord.
we're
Yes,
asking.
my lord. But Phulchand, Lordship, Phulchand was convicted because specific allegation against him, he gave threatening on the previous 2 days before, your lordship. If the accused person, victim uses that part, he'll face the serious consequences. And your lordship, immediately thereafter, he was seen, lordship, on the date of occurrence, when he was dumped behind the house of the victim, my lord. This accused person was seen and others were also then, of course, they were there, your lordship.
Conviction under 302 for giving threatening.
It can be a circumstance, your lordship.
But what is the main circumstance? The chain has to be complete.
That is,
Is it? Are you preferring any appeal against acquittal?
I have no instruction.
Then we have to enlarge him on bail.
I leave it to your lordship, my
There's no other way out.
last in
This will
theory,
also lead to acquittal.
that may not be observed in the I.
Will not.
Yes,
But what is this happening? We don't understand. The law is very simple. The same evidence, insofar as the occurrence is concerned, threatening, having bad blood earlier, these are all additional links. But the main occurrence is the murder of the person.
nobody has
First
seen.
of all,
Yes,
nobody
Mark.
has seen.
Yes.
Only chain in the link is these 6 accused persons were seen along with the dead body.
Yes.
Let's accept it as gospel truth.
My lord.
Even then, how can you pick one and acquit the others? If this is correct, if these witnesses or deposition is correct, all of them ought to have been convicted.
Yes.
That has not been done, and the state has accepted the judgment. On what basis then you single out one person? Please tell us that.
Lordship, records will reveal that during hearing, lordship, I'll try to satisfy. On the face of it, there is nothing,
What does PW 6 say?
lordship.
So now have you understood the
Yes, yes,
query?
my lord.
Yes.
Lordship, first PW 3, my lord. May I take your lordship?
PW 3 or
3,
3 and 4?
3, yes, 3, 4, and 6, apart from
3, 4.
PW 2.
PW 2 is the mother.
PW 2 is the mother,
Uh,
PW 3 is the brother,
the brother. PW 4 is the father,
yes,
and
PW
is
6. PW 6. my lord. Mother, lordship, yes, brother, I think brother, PW 6.
Sister-in-law of the deceased,
Kulchan, Abdul
PW.
Kalam Azam.
PW 5.
very sad. This is the state of affairs. This is the judgment of a sessions judge. Very, very sad. Take down. I heard Mr. Hawk Learned Counsel for the applicant. Also heard Ms. B. Bhuya, Learned Senior Counsel, bracket APP Assam, bracket close. Assisted by. Ms. F.
Yeah.
as
He
Huh?
appears for the inform.
Learned Counsel for the. Respond number 1, Mr. N. Uddin, Learned Counsel, appears for OP number 2, informant OP number 2. OP number 1, OP number 2. The applicant. Herein. Was convicted. Under section 30 of the IPC. By judgment in order dated 15/6/2022. Passed by the learned additional session judge from Borpeta. In connection with sessions case number 27 of the 2012. And sentenced to undergo rigorous imprisonment for life. And also to pay fine of ₹5 lakhs. Stop. Agreed by the improved judgment, the applicant has preferred criminal appeal number 131 of the 2022, which is pending disposal before this court. By filing the present application, a prayer has been made for suspension of the jail sentence and also for release of the applicant on bail. We have paid the grounds stated in the IA as well as the statements made in the objection filed on behalf of the state. According to Mr. Hawk, there is no evidence to convict the applicant under section 302 of the IPC for committing the murder of Saddam Hussein. Full stop. Moreover, Omar submits Mr. Hawk, the other co-accused having been acquitted by the learned session judge on the basis of same set of evidence, the applicant could not have been convicted under section 302 of IPC. Responding to the above, Ms. Bhuya submits that the applicant has been implicated by PWs 2, 3, 4, and 6, and he had also held out a threat to the deceased on the previous day of the occurrence. Therefore, the applicant cannot be treated to be on equal footing with the other 5 co-accused who have been acquitted. What is your submission?
I have also the same submission, madam, because you are convicted the judge.
Your legal aid counsel.
No, madam, therefore
Learned counsel has adopted the arguments of the learned APP Assam. Stop. We have considered the submissions made by learned counsel for the parties and has also gone through the materials available on record. We find that the police had submitted charge sheet against 6 accused persons, including the present applicant, for committing the murder of Saddam Hussein. First of, during trial, the prosecution side had examined PW2, that is the mother of the deceased, PW3, the brother of the deceased, PW4, the father of the deceased, and PW6, another brother of the deceased. First of, PWs 2 and 4, who claim to have PWs 2 and 4 have named all the 6 accused persons, including the applicant, who were allegedly trying to hang the dead body of their son in the courtyard of their house at around 2 a.m. in the morning. Full stop. In the morning. Full stop. The PWs 3 and 6 have supported their version. Full stop. However, the learned session judge held that there was no evidence to convict the 5 accused persons and consequently convicted the applicant for committing the murder of the deceased. First of the above conclusion of the learned additional session that is notwithstanding the observation made in the impugned order that the applicant could not have committed the murder of the deceased all alone. Full stop. Full stop. On a careful reading of the impugned judgment, we find that the evidence available on record against all the 6 accused persons were one and the same. Full stop. Moreover, none has seen the accused persons cause death to the deceased, but they were only found by the side of the dead body of the deceased in the wee hours. Full stop. It is no doubt correct that the presence of the accused persons by the side of the dead body in such unearthly hour and that too without any explanation, raises strong suspicion about their involvement in commission of a crime. Or crime. However, unfortunately, the 5 accused persons have been acquitted by the sessions judge, and the state does not propose to prefer any appeal against such order of acquittal. First of, be that as it may, since 5 accused persons have been acquitted, whereas the applicant has been convicted on the same set of evidence, we are of the view that the matter would require deeper scrutiny during appeal. We also find force in the submission of the applicant's counsel that there is a strong possibility that the conviction of the appellant stroke applicant might be set aside and he be acquitted during the final hearing of the appeal. Full stop. We are therefore of the view that a strong prima facie case has been made out for allowing this IA to stop. We accordingly direct that the applicant Gulshan Ali be released on bail on furnishing a bond of rupees 50,000 and one surety of like amount to the satisfaction of the learned additional sessions judge Borpeta. IA stands disposed of. Obliged. Epic condition.
Yeah, please, Your Lordship. IA for consideration of suspension of sentence and bail. The case is the charge against me is for killing of my colleague. I am a police constable, killing of my colleague in a quarter by my rifle, weapon. The prosecution case mainly basing on PW1, who is the wife of the victim. PW, they stated to be the eyewitnesses, PW2 and 3.
PW2 and 3.
PW1, 2, 3. All are stated to be the eyewitnesses, my lord. And basing of this, basically 3 witnesses, my lord, keeping brush aside the evidence of IO, my lord. There are 4 IO, mainly those who submitted the person who submitted, my lord, evidence of PW16 and the expert opinion, the most important vital, my lord, the opinion of the expert, ballistic expert opinion, PW17, my lord. My lord, before, my lord, I go to the, my lord, findings of the trial court, my lord. My lord, in the para 20 of the judgment, page 36, IA in the itself is in there, my lord. The expert opinion even not discussed, my lord, while coming to the findings, my lord. Though in the evidence it is discussed, my lord. I read, my lord, para 20, page 36. PW16 is the investigation officer who had conducted the investigation mainly has confirmed that he has seized the aforesaid carbine magazine, ammunition, empty cartridge and fire bullet from the residence of the accused and from the place of occurrence. He has exhibited the concerned seizure list and has also identified the said material in court. He finds ample corroboration from the others is that witnesses. It has elicited from him that he had not found blood stain from the stack here up to the quarter of the deceased. However, it is nobody's case that the body was decked from the ground floor to the quarter of the accused. Therefore, there is no question of blood stain on the entire staircase. The fact of the aforesaid seizure of the weapon and the ammunition were not disputed by the accused during this cross-examination. Interestingly, the accused has also not taken the stand during his cross-examination that the carbine bearing such and such number was required from the official quarter of the accused. It is contrary to the evidence. The stand accused has taken is that the carbine was not issued to him irrespective of the fact whether the said carbine was officially issued to him or not, if it is shown that some carbine was issued to fire at the victim and that the said gunshot would lead to death of the victim, that would suffice in any case. PW1 in his case,
Sir Ali, sorry to intervene. If there are 3 eyewitnesses who have seen the occurrence,
Malad,
whether the carbine has been issued or not, that we'll see at the time of hearing.
Malad, so far the eyewitnesses is Malad, your lordship, for a moment, Malad, if expert opinion may kindly be.
Expert opinion is an opinion. It cannot override eyewitnesses' account. If there is a conflict between expert opinion and eyewitness will prevail. That is the law.
Yes.
No, Malad, judgment of the Supreme Court, Malad, just 19.
With judgment, what is
Malad.
the point? Tell us.
Just I'm reading Malad, that your lordship. Malad. The stated to be eyewitness, not at all eyewitness. If your lordship permit me,
Cited in IA.
well, if your lordship permit me, my lord, I am reading the eyewitnesses, if it is PW1, basically this is. Well, just I am reading one paragraph, my lord.
Yes.
The learned counsel appearing for the, it is a case of 2019 6 SCC, my lord, 535, my lord. Ashok Shani, Jendra Shani versus State of Gujarat, my lord. Learned counsel appearing for the appellant mainly contended that fire bullet was not recovered and only the empty of the cartridge made to the bronze were recovered near the mango tree. Contention of the appellant is that since the fired bullet was not caused fatal injuries to the deceased, was not recovered, the ballistic expert opinion cannot give definite opinion as to the which weapon was used to cause the fatal gun owned up to the deceased. The learned counsel further contend that ballistic expert has stated that the only tested fired bullet C2 and from the C1 and examine only empty bullet recovered, and therefore from the evidence of ballistic expert, it cannot be said that gunshot injury was caused to the deceased only from the rifle recovered from the appellant. No recovery of the bullet cannot be said to be the fatal to the prosecution case, since benefit of the doubt is given to the accused on the other aspect, like darkness in the place of the occurrence and doubts who caused the fatal injury. We are not inclined to consider the merit of the contention by assigning the opinion of the ballistic examiner. There was a darkness at the time and the place of the occurrence, making it difficult for the witnesses to identify the assailant. The evidence of the eyewitness are contrary to each other as to the firing of the fatal blow. The guilt of the accused has not been proved beyond reasonable doubt, and the benefit has to be given to the accused. The conviction of the appellant accused number 1 such and under 305 is set aside, and such is ordered to release forthwith unless the purpose is referred to any other cases. Now, my lord, the ballistic opinion, my lord, your lordship kindly, my lord, that part is even not considered by in the judgment of the trial court. Just I am reading, my lord, the opinion in the evidence of PW 17. Exhibit, well, I am reading from the certificate copy itself. Exhibit A is the 9mm calibre carbine machine gun, and it is a factory gun. Exhibit A is found certifiable in its present condition. Exhibit B1, B2, B3 at the magazine house for 9mm calibre cartridge. Exhibit 1, B1, B2, B3 can be fitted in Exhibit A. Exhibit C are 9mm into 19 calibre live cartridge. Exhibit D is a 9mm calibre fired cartridge case. Now, Exhibit E, important, my lord, is a 9mm calibre fired bullet. Exhibit E has been compared with the tested fired bullet of Exhibit A. A is the, my lord, the magazine, my lord. But due to some extraneous marks on Exhibit E, opinion could not be formed regarding its firing. To the court, if it is fired bullet, any hard substance, then extraneous concern cannot be found on the fired bullet. When it is admitted in the chip, in the cross mallet, I did not find any extraneous mark of the empty cartridge case, Exhibit D. I do not know if Exhibit E, that is the bullet, was not fired from the Exhibit A. Well, it is our specific plea in the mallet, defense mallet. The gun which was in the, apart from that mallet, the seizure list evidence of the PW5 mallet, the issued gun was the different number and the seized gun was different number. It is admitted by the evidence number 13 mallet. It was prepared in the separately in the police station. He admitted mallet. Just I am reading mallet. Just I am reading the what he said, seizure list were prepared probably at the police station, but I cannot recollect. I saw the ammunition recovered and counted the same. In none of the seizure list, signature of the authority was obtained. In exhibit 2, 3, 4, 5, the quarter number of the authority not mentioned. In a carbine magazine, there can be up to 34 ammunitions. Each ammunitions contain manufacturing number. In exhibit 3, the number of the bullet was not mentioned, and only 9 mm bullet is mentioned. Exhibit 5, that is the ammunitions are not in seal packed. In material exhibit, the important vital aspect, 10-2, the body number of the carbine is mentioned at 16086-106. There is overwriting on last number 6. In material exhibit 10, the countersign of the in charge is not taken. Only the person to whom the arms ammunition was issued put signature. It is not a fact that exhibit was material exhibit was not issued to authority. We have pleaded, but the trial court had ignored our pleadings, our defense. It is not a fact that seized items were not recovered from the quarter of the authority. It is not a fact that material exhibit 10 was subsequently manufactured. Now it was again put before the another evidence, the same answer is there. So the carbine which was taken seized, it was seizure list was prepared in the police station. The number of the carbine is defined, which was issued to me. Apart from that, the ballistic opinion cannot be definitely come to the conclusion that bullet came out from that carbine because the calibre of that bullet is not tally with the carbine, the exhibit material T is not tally. That is why the expert opinion it is categorically and the IO contradict the evidence of the PW1 who stated to be eyewitness in the 208 under CRPC the copy which was supplied. Just I am reading 1 minute. The wife of the deceased
Not wife, widow of the deceased.
wait. On 17 যোৱাকালি 17-10-12 তাৰিখৰ সন্ধিয়া অনুমান 6:45 মানত বজাত মোৰ স্বামী মটৰচাইকেলে আহি মটৰচাইকেলটো বিল্ডিঙৰ আগফালে থৈ গ্ৰাউণ্ড ফ্ল'ৰৰ কৰিডৰেদি চিৰি বগাই ওপৰলৈ উঠি অহাৰ সময়ত গুলি ফুটাৰ শব্দ এটা শুনা পাওঁ। মই সেই সময়ত মোৰ স্বামীৰ মটৰচাইকেলৰ শব্দ শুনা পাই স্বামীৰ অহা বুলি মই ছেকেণ্ড ফ্ল'ৰৰ ষ্টেয়াৰ বাৰান্দাৰ ওলাই আহিছো। গুলি ফুটাৰ শব্দটো শুনা পাই মই চিৰিৰ তললৈ গ্ৰাউণ্ড ফ্ল'ৰৰ কৰিডৰৰ পিনে নামি অহা দেখা পাওঁ যে মোৰ স্বামী আতৰালি কোৱাৰ্টাৰৰ দৰ্জাৰ সন্মুখত চিৰিৰ তলত কৰিডৰত জখমী অৱস্থাত পৰি আছে। Now in the evidence what he stated, and this was contradicted by
So what is your point? The expert opinion?
the bullet which was came out from the gun was not issued in
And the expert was not examined.
it is the expert opinion examined in his
So
opinion
expert opinion was not considered.
was not considered.
And second point,
And second point is the IO, the evidence of the wife of deceased was contradicted by the IO himself. Just I am reading the IO evidence PW16 PW1 did not stated before me that he saw the accused fire to her husband when she was going towards on a staircase. Well, it was in the 208 copy which was supplied in the initial statement. This is the fact. He was not present at that time of so-called bullet firing. The pronunciation of name was also contradictory. My name was in the evidence of PW1. He stated Atwarili Marile. It was contradicted by other evidence, even PW16 IO. So far, PW2 evidence is also contradicted. PW2 did not state before me that he did not see Nazrul Ali from the deceased from a distance of 60-70 meters, but he stated that he saw him from a distance he did not state before me that he has seen the accused when the letter came with carbine in his hand. He did not stated before me that deceased Nazrul told his wife that Atwar killed him. Whereas in the PW, these two evidence stated that the Atwar killed him, but it was at that time it was. But these witnesses stated before me that deceased pointed towards the house of the accused. And in the evidence also, it is not a fact that the carbon bearing registration number such and such were not issued to the accused. PW6 did not stated before me empty case was seized which was lying in front of the house of the accused, but the stated before me same was lying at the place of occurrence. Man, it is a multi-state building. Man, so many police constable reside there. Man, all are arms bands and so many persons it is admitted in the chief mallet. Numbers of weapons are issued in the different service person. Man. It is no who did mal. It is a fact. Man, he gunshot. But who did it? Is trial court beyond reasonable doubt did not come to the conclusion that the bullet which has emerged from the gun of the carbine of the such and such number was issued to them. And the Caesar list was prepared subsequently. It was even overwriting. And the expert opinion clearly indicate that, my lord, the exhibit E opinion could not be formed regarding its firing. And I do not know if the exhibit is the bullet, my lord, was not fired from exhibit. So basically, my lord, it is a case of homicide by the bullet, man. The expert, that is why Supreme Court, my lord, say we are not in an opinion to the merit of the expert opinion. But so far the bullet is concerned, in that case when it was not required, here is a mallet bullet which cannot be put, cannot come to the conclusion that bullet was fired from that department. Now these are, and moreover the IO contradict all the three evidence which is stated to be vital as per the trial court judgment, mallet. PW1 herself admitted that so far the seen eyewitness of the concept, and PW2 also seen, 3 also same man. And that was, if your lordship, evidence of PW5, who is a Caesar witness, man.
Let the paper book be prepared, then we'll consider.
In fact, yes. And
Let
there's
the people-
contradiction.
Let the paper book be prepared. Two options you have, either take a dismissal or wait till prepare of paper. Which do you want? Quick.
Of course, man.
Paper book.
All right. But Mr. A.K. Hussain, learned counsel for the applicant, also heard Ms. S. John, learned deputy appearing for the state. After hearing arguments of learned counsel for both the sides, we are of the opinion that the paper book bonai se nahi?
No.
Paper book will be necessary for considering the subtle arguments made by the applicant's counsel on the question as to whether PW1 can be treated as an eyewitness in this case, and if so, whether there is in fact corroboration of a testimony by the PWs 2, 3, 7, and 9. Since the LCR has already been received, register to expedite preparation of paper book and list the matter thereafter for orders.
Hello.
But you don't have a good case, Mr. Hussain. We have scanned it. It's just that what you are doing is you are compelling us to actually finish off the entire appeal. We'll do it. We'll do it because the learned judge has dealt with these things.
No,
You said this carbine was not issued to me officially.
Right.
How does it matter whether it was done officially or unofficially?
Exactly, man. The bullet which was emerged from the that carbine, it also cannot be said.
What the police did is they did not know where the carbine came from. So they picked up another carbine and seized it. Therefore, it doesn't match. But does it mean he did not fire?
No, my lord, that is
These kind of arguments you can't even make in Munsif court. Forget the High Court.
man.
So rethink. We want you to take the order of dismissal in a more better environment. That's why the time.
Man.
Yes, next matter, please.
This delay.
I have for condemnation of delay loss. Service is not complete upon the response.
How many days delay? Appeal against conviction,
Yes, Lordship.
which section?
Under section
POXO.
6. Also,
So then we'll have to wait.
Lordship, yes,
Also is
for the
difficult.
victim.
Heard Mr.
yes, alum. Yes, alum.
S. Alam. Counsel for the applicant also heard Ms. S. John, APP also appearing for the state. Perused office note dated 14/11/2022. Await service. Since it is a POXO matter, await service report on response number 2, list accordingly.
Obliged. My pleasure, Lordship. Lordship, this I has been filed for
Objection,
bail,
Objection, this one?
for bail pending the criminal appeal.
We haven't filed our objection, I think, till date.
Why?
I don't know. It was not with me.
You don't want to file that?
No,
means
no, I'll file my objection.
This IA was filed on 14th of November.
Yes.
2020.
Oh, it's very recently. That is how. I'll file it.
It is a legal aid matter, Lordship.
Heard
We have been
Mr.
instructed.
Chaudhary Learned Legal Aid Counsel appearing for the applicant. Also heard Ms. S. Jahan Learned APP Assam appearing for the state, who pays for and is granted 2 weeks time for
Lodge.
filing objection, opposing the bail prayer. Let the matter be listed again after 3 weeks.
Obliged. Yes, sir.
Oh, recently. Khandakar, this is that matter where the other analogous matter is on board today. Lordship has ordered the other one to be listed. Khandakar, I filed my objection, it's on record. But Dhanu Ali, ki eta? Lal Banu, Mr. Das appeared on the last occasion and we had not even taken time for objection. So let me file that. And both the matters be taken up together.
But may I expect that bail should be granted to me, my lord. There is no evidence at all. And the scientific officer also said that we did not find any blood in the dao which was seized from the house of Ayueli. And I am not Ayueli, I am Shafur Rahman. And thirdly, my lord, there are videographer, 2 videographers. That is PW 26 and 23.
We'll grant you 1 week time
Yes.
and the matter will be listed on Monday, 28th. 28th of
Ah.
November, Monday.
Yes, yes.
As a
This
fixed
Monday
time.
I'll file my objection.
Huh?
Because there is a criminal conspiracy between the wife of the informant and the deceased. Wife of the deceased and the accused. There is an extramarital affair and then there is a conspiracy to kill him. So that is how both the matters should be taken up together so as to see whether there was at all a conspiracy between them.
But where is the counsel is not even.
Matter
present.
may be taken to you have no objection.
Mr. Ahmed was there as an amicus.
Well,
Oh, he's there.
I am replying one thing, my lord. My learned friend is saying that there were, the other day also said that there were discussions about their phone before the killing of Iyad Ali. This is Iyad Ali. But the telecom officers, that is Reliance Telecom and Airtel, both the officers came, adduced
Mr.
witness.
Mahmood, we will hear you for
Hmm.
1 hour, but the order will pass his list again on 28th of November.
Lodge.
The more you argue today, the more she will cover in her objection. These are basic common sense of a lawyer. You don't understand. Why are you disclosing your cards today? You will cover it in the objection. I'm not going to pass an
Perhaps
order.
he
We are not
cannot
going to
cover.
pass an
Because
order.
everything is on record, my lord.
All right, then you argue.
No, no, I am not
Finish
saying
up.
that.
You have to take note and cover these things in the objection. Yes.
On bail.
Yes.
Let the matter
But-
come up.
Lordship should pass the order on 28. So let it come 28.
He's
What
not
else to do?
spilling
There's
the
a
cards.
connected matter. The
Hmm.
state has to
That is
give it
the way, yes, I understand.
What can be done? Heard Mr. M. Mohammed Lanak counsel appearing for the applicant in item 13. None has appeared for the applicant in item 14. Ms. S. Jahan Lanak APP Assam submit test. Since both the matters arise out of common document, the state be granted at least a week's time to file objection in item 14. The prayer appears to be reasonable and is hereby allowed. However, since the Mahmood has expressed urgency in the matter, we'll have it on 29th then, 29th.
Yes.
Tuesday. Just urgency in the matter. Both these matters are directed to be listed for orders as fixed items again on 29
November,
um,
November 11.
11/2022. Registry to tag the objection, if any, filed by the state in item 40.
Mm.
We'll take up the matter and whatever order is to pass 29th, you come prepared. Whether the other side is there or not, we'll pass the order.
So he's
Yeah.
there, he's there for the other matter.
Acha, so then you write his name,
Ayush Chaudhary.
Ayush Chaudhary. We'll take up the matter on 29, no adjournment.
Lordship.
There is urgency, he's seeking bail. Yes. Acha, there are some other hearing matters. Who are appearing for them?
The Dhanji fellow thing is there.
My lord, I am for. Appellant, my
What is
lord.
your case? This bench will not be available from tomorrow.
My lord.
So,
My lord, this appeal is against
so we
judgment.
will hear
order.
the matter next week.
My lord.
Next.
Tell it.
This is a POXO matter.
We cannot finish the hearing today, so we'll have it next week. Both these cases next Tuesday. All right. Have you understood?
Understood, my lord.
Because if we start today, then you will have to wait for 1 month till the next bench.
And it will be next week.
Yes, we cannot finish up the matter today. That's why we'll have it on Tuesday. You argue and immediately we can pass an order. The bench combination will change. Next week.
Yes.
My learned sister is going to outline bench next week. So therefore, we don't want to start a matter and then you'll get stuck up. It will be bad for your clients. So both these cases list again for hearing on 22.
22.
So we'll take up the Pathak matter. Let us finish off the Pathak case
Yes.
and see if we can deliver the judgment today.
Lordship, my senior Mr. Gupta is just coming, Lordship, he was in another court. I
Yes, but
just informed.
we'll start because this is a Pathak matter. Bench is not there. Yes.
You've done your part, no? Aditya? Please, note to this, no?
Lordship, I have prepared a note, my lord.
Sir, no?
Should I reply or let him?
There's a note which was given to me by my letters print manner. On that same note, I have prepared, I put her things one side and the defense side once. So your lordship will get a clear
Just a
picture.
minute, just a minute. Yeah. Please take your seat. Photo. What is stepping inside? Stepping, S-T-E-P-I-N-G?
Lordship,
Is it a typing or you meant something?
Lordship,
Stepping inside.
which one, my lord? Oh, Lordship will be sleeping.
Huh?
I'm sorry, sleeping inside.
No, we found it twice. That's why we are asking you.
Maybe my lord.
Again in point 11, you again say stepping.
Accused admitted he was sleeping inside while injured was sleeping. Lordship. Typographical error, your lordship.
Okay, okay, that's all right. That's all right.
Yeah.
No, the question would not have come because it was found twice.
Yes,
That's why we
ma'am.
asked. Sometimes there are many things we don't know, we learn.
No, yeah,
All right,
proper
so
sleeping. Lordship,
do you want to say something more or?
I've
we heard
already
it?
prepared one chart for your lordship's perusal, my lord, giving what we want to say, because basically
Then you
the
reply,
circumstance.
let her make her
Very
submission, you reply.
Very well.
so whatever the other circumstances I have lordship given in my, in writing, your lordship. As per the evidence of the doctor, my lord. Injury was on the scalp, left side of neck as well as scalp, your lordship.
See, Ms. Bhuya.
My
let's Lessen your
My lord,
burden a little bit
my lord,
so that you can focus on the real burden.
Yes.
Which is quite an enormous.
my lord,
The death of the victim is homicidal.
Yes.
Let's not get into it.
my lord.
And in all probability, it is the accused who has killed.
Yes,
Correct.
my lord.
But the question is, unless the chain of circumstances is established by adducing evidence, the conviction will not be sustainable. That the court can't give moral conviction.
My lord.
That's the settled law.
Lordship,
Correct.
my lord.
Now, your star witness was PW
5.
5, is it?
Yes, wife,
Bhadramaya
yes,
wife.
yes,
She apparently recorded a statement before the IO
yes,
161,
my lord,
where she has implicated
My
her
lord.
husband.
yes. As well as 164
And
statement.
164, so definitely she has even explained
Yes,
why she said an
yes,
insane person has
my
killed.
lord. Yes,
She said, I thought my husband was insane.
my lord.
But was the 164 statement exhibited?
164 statement was not exhibited. My lord.
Exhibited. And that's what we are asking. Has it been exhibited?
Lordship, exhibit 7.
Exhibit 7. Who has
This is
exhibited?
161, Lordship. No, I think. No. Lordship,
So if that is not exhibited, the trial court said that although it is not exhibited, the court can look into case diary. And so court looked into the case diary and took cognizance of that. All right. Now, 164 statement is not a substantive piece of evidence. It has a corroborative value.
yes,
161 doesn't have any corroborative value. Only purpose is contradiction. 164, both corroboration and contradiction. But it falls short of a substantive piece of evidence. So viewed from that angle, there are only 3 or 4 circumstances which are established on the evidence on record. One, that the victim is to stay in the same house with that of the accused. Correct. Second, the incident occurred in the courtyard of the house and she died a homicidal death on being hit by sharp weapon. There are 4 injuries. Postmortem report mentions about 4 injuries. The deep cut incised injuries. Is that correct? Or
yes.
am I
On the
mixing up?
brain as on the neck,
Yes.
backside of the neck also.
And the 4th circumstance is that the victim, the accused was sitting in his veranda. He never did anything to, he was totally nonchalant about the incident. Coupled with that, there is some extrajudicial evidence, confession coming in, which is obviously a weak piece of evidence.
Is leading to discovery.
That Discovery is what? That thou is appears to be something else, but that kind of thou is there in every household.
Kolomkotari is for pruning the,
That's there in every
Yes.
household, but all right.
yes,
That
but
was in front of the police, extrajudicial when.
no,
police
no,
was-
after he was taken into custody, he was lordship,
What we wanted to know.
Yes.
is one of the witnesses who has referred about extrajudicial confession.
yes,
In his evidence, the presence of police is not there.
yes.
My lord, that in fact till yesterday, I also thought the same. Today morning when I read it again, he says on the next day. Now from the police, it is clear that on the first day, the police arrested him, took him to the police station, interrogated him, his wife. On the next day, he brought the accused back. And after that, and the rest of the witnesses corroborates this, that he made the extrajudicial confession before police. The PW6 had said on the next day, he made the statement before the public, police came. But now this has to be read with all the others. So if your lordship sees everything, it is on the next day.
All right, that's the question we are putting to the APP. That this is one area because 25 and 26 will hit the material if it is in presence of police and in police custody during the course of investigation. Throw some light when he made the extrajudicial confession.
Lordship. My lord,
Which finds some corroboration, whatever be the worth of the evidence.
lordship.
Was he in police custody? And was it made in presence of police or he made it? in absence
May I
of
take your
police?
lordship to the evidence of
You
PW6?
please take note of the points.
Yes, my lord.
Then you
Yes,
can respond.
yes,
This is one.
yes.
Then you also please address us. Can the court rely upon a 164 statement which is not exhibited? If so, what is the principle? Because the trial court has done it. We have to either say it is right or it is wrong.
Hmm.
If it is wrong, then the consequences will be something. If it is right, then it can be looked into. To what extent?
Lordship, that part I have not examined, your lordship, whether, since it was not exhibited, whether court may still rely on 164 statement. The face of it, 164 statement is not the substantive evidence, your lordship. And whether an unexhibited document, court can rely on it.
But it can be proved.
Yes, your
It can
lordship,
be exhibited.
my lord.
But here it has not been exhibited.
Yes,
But nobody has denied that.
yes,
The existence of this document is not in denial.
yes.
Has
Lordship.
anybody in the testimony spoken about a 164 statement? Is there any cross on that? It's another,
Lordship,
like almost every case, very shabbily conducted
My lord.
investigation and trial. But we don't want to be so ultra technical
my lord.
in these matters. But the answer has to be on the basis of a legally tenable ground.
My lord,
And these will be very, very crucial factors.
my
there.
lord.
You are not prepared.
That aspect I have gone into, your lordship, regarding the 164 statement, whether any of the witnesses have told about that. May I see, your lordship?
I think the question was put to PW5. And
Yes,
PW5
let us
in
see.
her statement. Yes, it was, I was also produced before the
Mm.
magistrate for recording my statement, and accordingly, my statement was recorded by the magistrate under section 164 CRPC.
You are reading PW?
PW5, my lord.
Page
At
16.
16 on the top. This is during cross, my lord, by the prosecution. I was also produced, the lordship got that. I was also produced before the magistrate for recording my statement. And accordingly, my statement was recorded by the magistrate under section 164 CRPC. What is only admitted is that she did give a statement. Now, the contents of the statement and what she says in the witness box is not the same. Is not the same. Now,
She admits that.
she had given a statement before the magistrate. Now, whether however, it was not exhibited, it was not shown to her, and your lordship will see nothing was done.
Hmm.
Now, normally, since she has already denied the contents otherwise in the witness box, because in the witness box, she's clearly said that, no, it's someone else. And when she comes, she finds her husband sleeping. This is what she speaks, says in the witness box. This is what is in the witness box. Now, to prove the 164, ideally, the magistrate in whose presence she had given the statement should have also been produced, my lord. Now, to that effect there's one decision of Madras High Court, my lord, if your lordship what wishes, I can type that. Extra copy. This is reported in 2014 to Madras Weekly Notes 290 Division Bench, my lord. Just 2 paragraphs. I'll just read it slowly, my lord.
First, tell us what is the
On
observation?
164, my lord, how to take it on that. Basically, that the magistrate ought to have been also recorded. Then, even then, it is not a substantive.
Even the
piece of
magistrate
evidence.
is not examined.
No,
No. So that perhaps cannot be taken into account.
Why it was not done?
lordship, there's nothing on record.
So there will be strictures in this case. That's what
No.
we are thinking.
Lordship, may I, although these bands will not be available. Lordship, can this matter be done here?
1 minute, 1
Yes.
When are you coming back?
Till second of December. Okay. For 1 week.
The 2nd December, you're coming to Guwahati.
Yes.
Otherwise, there is nothing, my lord. There's no evidence that can be said to be evidence. The
Yeah,
only three
this
things,
is a case which appears that
perhaps,
the accused is guilty, but
but there's no evidence.
neither the IO knows how to investigate, nor the prosecution knew,
Very sad.
nor the judge knew how to write a judgment.
Very
We are
sad.
not
It
going to
depicts
gloss
a
over these
Sordid
matters
state of
again.
affairs, my lord.
Huh?
It's very sad state of affairs, my lord, the way things have done. But then if we have to see the
The
evidence,
most easiest thing is to take a hyper-technical approach and finish it off. I can just dictate the order just now, but this time we don't want to do it. Maybe we'll summon some officers and ask them to explain what is this happening. But to do that, we'll have to be very sure if what would be the impact.
Yes.
There is a 164 statement. The PW6 of PW5 admits about that. IO
It
doesn't
wasn't
exhibit it.
exhibited.
Magistrate is not examined. The trial court takes note of that statement.
perhaps ought not to have been taken account because once
What
she
is the
said,
law? That's what. we
but
are
the
asking.
moment she says that she has given, she should have been, her notice should have been drawn to the 164 and it could have been exhibited at that moment.
That's right.
That could have been one approach. That was not done, sadly.
Who should have,
The
that,
prosecution was,
Prosecution should have done
cross-examination,
it, they did not
prosecution
do
should
it.
have done that. They have not done that. It's too late in the day to rely on that. Perhaps, my lord, that is my opinion.
But every lapses in the prosecution side did not give benefit to the appellant, your lordship.
If there is no
And
evidence-
lordship, so lordship, may I look into that aspect, whether non-exhibiting 164 statement, non-recording of the evidence of the magistrate, how far it is fatal, your lordship, that aspect, although bands will not be available.
We'll have it on 6th of December.
6th of December, yes, my lord, yes.
And its sister will be back
My lord.
by then.
It will remain as
This
part
issue
of,
is important.
Exhibited 1, Exhibit 7, that is the statement of.
yeah, 161.
161.
Yes.
161.
Yes. Was it available? They have exhibited in the CD?
Yes,
itself or-
161 lordship, it was put to,
Page 80,
Yes, it.
at 80 in the paper book. It is there. The 161.
page
statement,
22, IO
it's
statement.
page 80.
No,
Where
As
is-
per
where is-
paper
where is
book,
this?
80 is the 164 statement.
No, 161 is also there.
As per
Page
paper book, 80 is in.
164 statement is also there.
Yes, it's there.
One
ready.
is- but, at 80, it is 161, and 82 is 164. Statement of witness so and so, recorded under section 161 CRPC in consonance with so and so case.
Yeah, this is 80.
This is 80.
Yes.
This is the 161 statement. And at page 82, your lordship will find the 164 statement recorded by the judicial magistrate first class. Only thing is that 161, she became hostile. She's not sticking to her version in 161. She's denied. Suggestions were put, but she denies.
Sir, 161 can be to prove a contradiction.
Yes. my
Yes,
lord.
only for contradiction.
And it has to be
Statement
supported.
can
It's gonna exhibit it.
It cannot be exhibited,
cannot
that's
be
right.
And it
is
was
not
shown
admissible.
during whether,
Only for contradiction.
yes. And hostile, that aspect I have not taken into account because there is no independent witness which will support that contradiction part. In the evidence on record, there's nothing. If someone else would have supported that part, it would have been admissible, my lord. Lordship, then on 6th, my lord. 6th.
What do you say, let's settle these
Yes,
issues,
my lord.
because this, most of these appeals, matter of 15 minutes, but complication is because all kinds of funny things are done by the IO and that's the case all across the country. And more so in our state, what to do? That is why somebody has said that it is the judges who are put in trial, not the accused or the.
I never find these weapons are never sent for forensic. They could have sent,
That is also
they
lordship.
never do
Not
that.
send it down for forensic.
At least that could have given us some clarity.
We'll find out what has been done so far.
Lordship.
Heard Mr. K. Goswami, Learned Senior Counsel, appearing as amicus curiae in this
My lord,
case.
my lord.
Also heard Ms. B. Bhuya, Learned Senior Counsel, bracket APP Assam, representing the state. First of, during the course of hearing, the Learned APP has sought further time to examine certain legal issues arising in this matter and address this court. Considering the importance of the issue arising for decision in this case, we are inclined to grant time to the Learned APP. However, this bench is not available for next 2 weeks, hence register to list this appeal again on 6/12/2022 as fixed part-heard matter, subject to availability of the bench.
My lord.
Now, the dead body was inside the house of.
Yes, yes, in the courtyard.
But is there an explanation from the accused side, accused?
Accused
Yes,
was
yes,
asking
I stayed in
at-
313, my lord. He gave the answer. He was present. He was present at the place of occurrence. He was there.
His
Question,
presence is
lordship, I
not
have put.
disputed. His presence.
He was
is,
very much a normal human being. Mother is lying, your lordship, at the time when the other witnesses arrived. The dead body was like the body, the
she
victim was
wasn't
not there.
dead.
She was not dead.
dead. She was
So
lying
what
in
they
bed.
would have do, the lordship, he would have taken her to the hospital, my lord. He did
was
nothing.
sitting and his
These
wife
are
went
all
for help.
additional links in the chain of
Yes,
circumstances.
yes,
But the chain has to be complete.
yes.
Even otherwise, maybe it is possible to hold. But unless we come to a conclusion that the Learned Trial Court was justified in taking cognizance of the 164 statement, because that has been heavily relied upon.
Yes.
If not, even if the conviction is upheld, we have to give fresh reasons for.
Yes.
The lordship will have to reappreciate the evidence and give a finding, my lord.
Fresh reasons. have to
Yes,
be
my
given.
lord, your lordship may do so in
And
appellate
if
stage
we
also.
find that it can be done,
Yes,
then we may.
it can
say
be
we
done,
agree
my
with
lord.
it.
That can
But
be
if
done.
it cannot be done without exhibiting, if this document, at least looking at the case diary, court, there are judgments to say that the court can look into the case diary to satisfy its conscience.
Yes,
But satisfying its conscience is one thing, and extracting materials and planting it in the judgment as the
No,
basis of the
yes.
judgment is completely another thing. So if we cannot agree, we have to disagree. Then we have to say whether still it is, the case has been proved or not. So these things can't be done hypothetically. We have to go stage by stage. Have you
My lord.
understood it?
Lordship.
We may agree with the trial court and say nothing more, except for giving the reasons why we agree. If we disagree, then the option is either to allow the appeal and
Yes.
acquit him, or even after disagreeing, we may still convict him for different reasons. There we have to say why the trial court was wrong, what ought to be the correct approach, what is the law in this regard, and therefore what is our view. We can't do this unless you, both sides, you address the court on these
Lordship.
legal issues. It is not a
On 164, I have the decisions, but my.
164, what is the decision?
164 cannot, is not, my lord, 164
not the
has to be
point.
That is
first
not
of
the
all
point.
Not the
brought
point.
into evidence. Here, the one.
That is not the point.
Correct.
The point is, can it be looked into by the trial court?
So that is an error which has been committed. Now, your lordship is sitting in appellate court here. It's a criminal
No,
appeal.
but why do you say it's an error?
But because that 164 was not proved, the magistrate was not.
Where is
brought,
the
my lord.
authority to say that?
But I have a Madras decision.
Hmm.
I was about to cite that. I have brought it. Your lordship wants to hear more. That is different, my lord.
If it is not exhibited,
Yes, my lord.
it cannot be relied upon.
Because the contents have been denied. Somebody, if the person making the
Mr. Goswami,
164
have you seen
statement
the
stick
observation?
to her version, then there was no difficulty. Here, she did not stick to her version. Now, the question is whether 164 was made voluntarily or not. Now, there is a procedure how to prove it, my lord. These things were not done.
That's not the point, Mr. Goswami. Have you seen the observation of the trial court regarding this 164
Yes, my
statement?
lord.
Come to that part. Which paragraph?
Judgment to deals. Para 24, your lordship is
Yes,
referring
please
to?
read it.
The IO during his evidence testified that he got the statement of Bhadramaya Chetri recorded under section 164 of the CRPC. Inadvertently, the said statement was not exhibited, though the said statement is in the case record. Therefore, I have taken judicial notice of the said statement under section 164 of the CRPC of so and so. In her statements under so and so, she stated on oath that at the relevant time, her husband was quarreling with his mother for money.
All right, that is what is there.
This
in
is
the-
not substantive piece of evidence. This is
Correct.
what she has.
But could
is
he
there
have
on the
taken
record.
judicial notice of
Yes,
this?
my lord.
Yes, my lord, that
Yeah,
perhaps.
lordship, whether the learned trial court can still rely on 164 statement?
Could the
Yes,
trial
I'll go
court-
through it, your lordship, the judgment still can rely on.
Does your Madras judgment deal with this part?
Just two paragraphs, I'll read it out and
All right.
a statement recorded under section 164 is a former statement given before an authority, namely a magistrate, who is legally competent to record the statement by virtue of the power conferred upon him by section 164 CRPC in order to aid the investigation conducted under chapter so and so. Section 157 Evidence Act says that the former statement must be proved. Therefore, the witness who gave the section 164 statement should be made to prove it while marking the statement through him. If the witness admits in his evidence before the court that he gave a former statement to the magistrate and the statement shown to him is that, then the section 164 statement stands proved. No, that was not done with utmost
That's
respect.
not the question.
In that case, the magistrate who recorded the section 164 statement need not be examined. In that situation, the magistrate need not be examined. If the witness completely denies that he gave a former statement before the magistrate, then the prosecutor should dispute it and suggestions should be put to him that he did give a statement and his signature in the statement should be marked. If he denies the signature also, then also should be disputed and suggestions that the signature found in the section 164 statement is that of his should be put to him. Therefore, thereafter the magistrate should be examined and the section 164 statement should be marked and proved. The investigating officer should also say that on his request, the magistrate recorded the statement of that witness on such day and such date. Only this will complete the circle in a case where the witness denies everything. Only this, even if this process is completed and the section 164 statement is proved, then also the statement 164 statement cannot be treated as substantive evidence and the accused be convicted based on it. The court can only give a finding that the witness who gave the section 164 statement is a liar and take action against him for giving false evidence. But here, thing was done. That is lying on the record. How can one take judicial note of that? That is not a piece of evidence.
That's the point
It
here.
has to be proved.
Can the court take judicial notice of something in the record?
Well, at utmost respect, my lord, my submission that it could not have because it is not proved, my lord. If something is not proved in a criminal trial, how can that be taken into record? It has to be first proved. It was never proved.
She was denying her statement. Because here in this case, she admitted that I have been.
Anyway, the issue is a little more complicated than. Is a little more complicated. This is a lapse by the prosecution.
Sadly, that's what I said, my lord, because in 161 is also there, 164 is also there, despite this is not proved.
You want
Lordship, the IO says, my lord, at page 21.
Hmm.
Next day, I seized the die as shown by the accused from kitchen so-and-so, exhibit is the so-and-so. I took the thumb impression. And thereafter he was forwarded to court. Bhadrama Chetty was forwarded to the court prepared to record a statement under 164. She was sent for examination on 164, my lord. At page 21, second paragraph. And in a cross-examination also, your lordships, he was put that question, my lord, regarding confession statement. Second paragraph regarding 164 statement.
No, otherwise you see the case lies in a very straightforward campus. This appellant, he didn't have any income.
Remorse.
He was an
Oh, yes.
alcoholic. So he used to repeatedly ask for money from his mother and his wife. So previous day or few days back, they sold a bullock, 27,000 rupees. He wanted his mother to part with some money.
Yes.
His wife has declined his request. He was insisting that his mother gives it. She also did not relent. Therefore, it is apparent that in a fit of rage, he took that and hit the mother. And she suffered grievous injuries, was lying in the courtyard. And the occurrences in all probability been seen by the wife. She was also there. But she has also stated before the IO that hearing repercussion from the public, she had to change her version and say that some insane
Mad person has it.
and
Yes.
gone towards the river. But there was no such insane person. So these three persons, their presence in the scene is established. There is nobody else in the picture. The motive is established. The accused has himself led the police to recovery of that Kalam Katari, which was seized by the IO. Then one of the witnesses says the nephew has come and told him
Yes.
that it is his father who has hacked his grandmother. So if he has heard it from the nephew, that would be admissible in evidence.
Minor.
But the nephew, who is a
Was
minor,
not
has not
examined.
been examined.
Would you
Nephew
think-
has not been.
Sorry, madam, sorry to intervene, madam. That part, that witness never said before police, and the police confirms that in the police, when during his deposition, that this particular witness never told before him that the nephew had come. Now, if that has to be believed, at that moment, initially, that witness ought to have said that, because this has now come after so many years in the witness.
All right, so we take it as improvement and we material improvement and we ignore it. Then the other aspect is extrajudicial confession. 2-3 persons have said he has made the confession. But the question is, did he make these extrajudicial confessions in presence of police? And when he was in police custody and during the course of investigation, was the police case registered by then?
Yes.
This is answered, my lord. If your lordship comes to PW6, who's the only one who said public, he says, I was away from my house and on the next day, Arjun Shetty confessed before the public in my presence that he had killed his mother. Now, this is on the second day. Now, that second day, all the witness, including police, have clarified that, my lord, I will take your lordships to PW 9. Your lordship will find, says, I interrogated I took up the investigation myself. I interrogated the informant at the police station itself. Thereafter, I went to the place of occurrence. That the first day he goes to the place of occurrence. And then I met the wife. Then I took the accused in my custody. I also recorded the statement of the witness found there. I prepared so-and-so. Thereafter, I brought the accused and his wife to the police station. The first day, he brings the accused to the police station. I again interrogated the accused and recorded his statement.
But he was not arrested.
My lord, I also recorded the statement of so-and-so on interrogation, disclose so-and-so. Then your lordship will find towards the end. Thereafter, I again interrogated the accused admitted. And then second day, he mentioned, my lord. He was kept in the police custody, and on the second day, he was taken back to the place of occurrence.
No, where does the IO say when he apprehended, when he arrested?
On the first day, he was taken into custody on the first day. I interrogated when your lordship will get it about 10 lines from the top. Thereafter, I went to the place of occurrence. This is after getting the information. Visited the place of occurrence, found Arjun Shetty in the house, noticed so-and-so. On being asked, Arjun Shetty did not reply anything. I also met his wife. Then I took accused Shetty in my custody. Has your lordship got that? On the first day itself, he was taken into custody. Then he was brought to the police station, and in the police station, he and his wife both were interrogated. Later on in the police station, it says that he had admitted. That is when, and the wife was also interrogated, and then a statement was
But
sent.
then he was sent back home.
No, my lord. Next day he brought. This I found somewhere. I had found that somewhere, my lord. On the next day, the police had, in fact, some of the witnesses have also said. No, but somewhere.
There must be some arrest memo in the case.
Lordship,
Yes.
I'm seeing that.
I remember exactly seeing that line, but I'm not getting that now. Fine.
Arrest memo is of my lord, 1710. 1610 1610 on the date of occurrence.
That is the date of occurrence.
Yes.
So
Date and time
therefore,
of arrest 1610 10 PM.
therefore, when he was, he had allegedly made the extrajudicial
He was
confession.
arrested.
He was in police
Yes,
custody.
yes.
That will not.
Let
be
me
admissible.
see.
That is what I was trying to say. Because PW 8 clarifies it. PW 8 says. On the same day, police came, and I also went to the house of the accused. I have noticed that so-and-so. Police arrested the accused and took him to the police station. And on the next day, police brought the accused. And I came to know that police is one down on being led by the accused. And all the witnesses says on the next day, police, the accused made that extrajudicial confession, including PW 6. So it is undoubted, and it is very clear that this extrajudicial confession was made in presence of police.
That is not.
It will be hit by 25.
Record will
26.
reveal, your lordship.
Now, the
timing.
statements, we will go by the depositions.
But we'll still see whether the chain is complete.
Yes, yes. And here, my lord, if your lordship, whatever the initial circumstances, absolutely your lordship is correct. These are those inferring circumstantial evidences. Now, if that leaves no doubt for anybody else, then of course your lordship, on that basis, your lordship can uphold the conviction. But if a doubt comes, now here, though it is mentioned what, now the Bullock part comes in 161, not in these depositions before the court, my lord.
But IO has said about it. IO has said about it.
Yes, my lord. Now, here, during witness box, the the inferring circumstances that are coming is number one, that the accused was present in the house. In the morning, the wife of the accused goes to the field. When she comes back, she finds her mother-in-law lying injured in the courtyard, and the husband was sleeping at that time. And then she went out. She goes and informs her brother-in-law, that is PW2, and the wife of PW2 about the incident that somebody had killed her mother-in-law. And this is corroborated by PW2 and PW3. Then they come and then they find that the accused is sitting in a chair and the mother is lying injured there itself. These are all admitted. And then there is a gap.
So therefore, Mr. Goswami, will it be correct to say that the chain of circumstances will be deemed to be complete if it leaves no room doubt that somebody else have done it? As long as the doubt is there, chain will not be
completed.
But the moment that doubt is
Because the
dispelled,
moment there is a doubt, the benefit of that doubt.
what is the doubt here?
Well, whether there's a two views. I can't say doubt, but certainly there is two views. One view is that going by everything, looks like it is the accused who's done it. But the other view could be somebody else because the wife went and told the brother and sister-in-law immediately after the
That is the
incident.
That
That is there. And we cannot
164
ignore that.
statement is creating all the problem.
Well, 164 for the time
Because
being.
she has explained why she had said so.
But
In
that,
her 164
that if we not go into right now, what is there in the deposition of PW2 and because in there she says insane, but PW2 and 3 doesn't say about insane person. They say someone. And PW2 also says one because in the house, along with them, it appears two sons of the
No,
accused
that's all
also
right.
resides.
What we are asking you is, you see, PW5, that is the wife, she has been declared a hostile witness. And her version does not find corroboration from any other evidence that somebody else had come in. So can we not discard her testimony as wholly unreliable? If we do so,
That only on the basis that the mother-in-law resides with them, on that basis, your lordship will have to uphold the conviction. Because there is no other evidence. There is no other evidence at all.
no, and the accused was present there. He
That
has
only the,
handed over.
well, that is after the police came. Maybe he was, that was
No,
not.
but the
and
discovery
he
discovery
had-
part will be.
Discovery
admissible.
part is
Yes.
he's only handing over it down.
Is
That
there
down is
a,
a
is there
common
a
down.
entry in the case diary that the accused had led to discovery of? the
Yes,
house?
yes.
That is after his arrest on the next day.
That obviously will be after arrest, but that can be proved under 27. Under section 27 of Evidence Act, it can be proved. There is no cross-examination of the IO on that point.
No, madam.
That the accused, why would he hand over a dhow if somebody else has come and killed his mother? He doesn't say somebody else has come.
No, he does not. No explanation.
That is the version of the wife. But he doesn't say so.
If the circumstances inspires confidence, your lordship can always uphold the conviction because that is the law.
Lordship, on 16/10, at 9 AM. Now on as being laid by the arrestee Arjun Chetri, in the meantime, he was arrested, my lord.
Hmm.
I have recovered and seized the weapon used by him in committing the murder in presence of witnesses and in connection with the case.
These Caesar witnesses have been examined.
Yes, they have been examined.
What is witnesses, Caesar witnesses? There is a problem here. The incident took place at 10 AM
Yes.
and he seized it at 9 AM on that day.
9
No,
AM,
the
yes,
next
your
day,
lordship.
I think.
Hmm?
Caesar
Oh,
is next
9
day.
AM, 17/10.
1710.
Caesar is
Case
next day.
diary to dated 17/10, 9 AM.
She said 1610, that's why.
7.
No, I'm sorry, my lord, no, 16/10 is a date is given and after that, case diary number 2 dated 17/10. It was open on 1610. CD was open on 1610. Caesar witnesses are there, Your Lordship. Lordship, PW 8.
Yes,
Police seized the dhow in my presence. Page 19, my lord.
he said he had noticed blood in the courtyard.
Yes. Even PW 6 made the, give the signature on the scissor list now.
PW 7 is also there.
Yes.
6, 7 and 8.
Yes.
So extrajudicial confession goes. So unless something really good comes out, 164 statement goes, 161 goes.
That part, Lordship, may I also look into any judgment, Your Lordship, whether it's fatal, non-exhibiting 164 statement and relied on by the tried court, whether it is fatal, man.
Yes, that's the only point here,
Yes.
because the 164 statement has not been proved.
Yes.
There's no doubt about it.
Yes.
If it can be relied upon without being proved,
Yes.
then where is the need to prove it?
Yes.
In every case, it can be relied upon. So prima facie, we don't think it can be.
But it was put to the witness, my lord, PW
How
5.
can the court take judicial notice of something,
Yes.
the sanctity of which is still to be established? It is not a certified copy of a judgment on an order or a public notification.
Even in 164 statement, there are judgments, Your Lordship, but may not rely on it.
That also goes, evidence of PW 5 goes as hostile witness. What remains is
Leading to discovery, last scene, and leading to discovery, last scene, as well as
homicidal
explanation.
death,
Yes,
the presence of the accused at home, the place of occurrence.
his
time of
conduct,
occurrence,
my lord.
His conduct,
These three circumstances only.
and his silence in 313, where he has not alleged that somebody else has come and done it. So we will have to see whether it's still, there is a doubt. And if the appellant can be given acquittal on benefit of doubt. That's the only question here. The other aspect of the matter, which we would request both of you to also examine. Is it a case which will come within the fold
General
of
exception.
exceptions?
If Your Lordship holds that there was a quarrel prior to that, then it may be
That
brought
case
in.
is not at
Perhaps
all-
he didn't have the intention to kill, maybe.
That aspect of the matter. has
Yes,
not
I have
been-
brought judgment, but on the vital
No,
part of the
ju-
body.
judgment goes later. The
Lordship,
first-
it can be,
first
Lordship,
say
if
what
it
is
holds,
your
my lord,
opinion
my
and
lord.
Why?
my lord,
Judgment will come when you want to throw more light on your opinion.
my lord.
But you don't start a case because there is some judgment.
No,
You
my
start
lord.
a case
Yes.
because this is what you feel.
If Your Lordship holds there was quarrel prior to that, then Lordship,
Can these circumstances be stated to be enough to come to a conclusion that this matter comes within the fold of exceptions of section 300? If so, why? What is the reason? If not, why not? This is the debate here. If the answer is in the affirmative, then he has to be given the benefit. If the answer is in the negative, then no. But both ways, the court will have to give reasons.
Yes, my lord,
That is the problem.
my lord.
Otherwise, these matters can be,
No,
if it is a press of button, red or green, we'll decide 5,000 cases a day. But we have to give reasons for every small thing, particularly in a matter of this nature where a person's liberty is in question.
curtailed.
Therefore, we can't rush into the decisions here.
No,
So that's it, then we'll have it on 6th
My lord.
December. Please spend some of your valuable times and go a little deeper. Mr. Goswami, we appreciate your
lord.
effort, your argument,
My lord.
but go a little deeper and see whether we can settle the law a little more.
Thank you, my lord.
Yes, any other miscellaneous matter, short matter? We're not going into a new hearing today because that matter will get stuck up for another 2-3 weeks. Any short matter? Anybody? 5-6 witnesses where the judgment can be dictated right now. Will take time. The other matters listed were also long. If you can complete your argument in 1 hour, we can dictate the judgment in another 1 hour. Any matter?